Hi. So today we'll be discussing a Supreme Court judgment, which essentially is an SLP arising out of an order passed by the Gujarat High Court. The Gujarat High Court was entertaining a Section 11 application seeking appointment of an arbitrator and had finally appointed the arbitrator. The SLP that was filed before the Supreme Court actually raises some interesting questions which are worth discussing. The contract between the parties wherein disputes arose and therefore an arbitrator was sought to be appointed was actually performed in part by one of the contracting parties, and that performance was acknowledged by signing of some documents. This part performance and the acknowledgement of the performance led to some of these interesting questions being put before the Supreme Court and the discussions which ensued from there on. So just to kick off the discussion, I'll request Shruti to give us a little bit of an idea about what is the factual matrix of the case, who are the parties involved, and what basically led the parties to come to the stage of the dispute.
Right. So thank you, Arjun. I'll just shed light on exactly what you said, which is the facts that led to the such a question arising before the Supreme Court. So in this case, there were two parties. The respondent before the Supreme Court, Krish Spinning, had obtained an insurance policy from SBI General Insurance, which is the appellant before the Supreme Court. So during the coverage period, two fire incidents had occurred. For the first fire incident, there was some sort of a disagreement in the valuation of the claims between Krish Spinning and SBI. But eventually, Krish Spinning agreed to the valuation as proposed by SBI, which was a reduced valuation, and signed on the consent letter and also signed a discharge voucher. After this, the claims for the second fire incident were processed. And a short while after the second fire incident claims were processed, Krish Spinning raised its original claim, which it had asked for for the first fire incident, which was a higher amount, and stated that it had signed the discharge voucher and the consent letter under the fear that if it had not done so, then it wouldn't have gotten its claim amount for the second claim, which it appears to have agreed to. So this is why Krish Spinning filed the Section 11 application initiating arbitration that led to the present dispute.
Thanks, Shruti. So essentially what we understand is that there was some sort of an agreement between the parties on performance of the insurance contract. The insured amount was indeed paid by the insurance company, and basis the acknowledgement of that amount being sufficient compensation to the insured, there was a contention that was raised by the insurance company that all obligations arising out of the insurance contract stood satisfied and acknowledged that there exists no further obligations on the part of the insurance company. So in this situation, we would want to understand that how do disputes still survive between the parties to the contract. So Shruti, if you could help us understand a few concepts. One would be the arbitrability of disputes when the contract which contains the obligations actually stands discharged through performance of the parties. And the second is that if a contract has been extinguished by execution of a subsequent document like a full and final settlement agreement between the contracting parties, then how does the arbitration agreement contained therein still survive and still enable the parties to initiate arbitration proceedings under that contract?
Right, so these are really pertinent questions which have practical implications in day-to-day dealings when parties are trying to enter into some sort of a settlement agreement. So I'll just address the questions one by one. So I'll first explain the process of discharge. So under the Contract Act, Section 63 provides for discharge of a contract by way of accord and satisfaction. So if there is a full and final settlement between the parties, then it can be said that the contract between them, the obligations that arise out of that contract, have been discharged by way of accord and satisfaction. Now, when I say that the obligations have been discharged, then how does a dispute still arise and how does the contract still survive, right? So while this is the construct under contract law, when such a case comes to arbitration or when the contract has an arbitration agreement, certain principles of arbitration also come into play. So one of the important principles of arbitration is the separability of arbitration agreements. So an arbitration agreement is considered to be separate from the substantive contract, which is why what happens is, even when parties enter into this sort of an arrangement, sign a discharge voucher or enter into a full and final settlement of their obligations arising out of the original contract, the arbitration agreement continues to survive because that has not been discharged. So which is why the disputes that arise from such a discharge, whether or not the contract has actually been discharged, whether there was any duress at play or any coercion at play, all of these are can therefore be arbitrated under the arbitration agreement, which is still surviving. So this is why the disputes continue to remain arbitrable, and they can be arbitrated under the arbitration agreement itself, because generally arbitration agreements have wordings like any disputes that arise out of the arbitration agreement, in relation to the arbitration agreement, under the arbitration agreement. This is a very broad scope, right? So all of the disputes that arise in relation to whether or not a contract has been discharged can be arbitrated under the arbitration agreement. And so a determination as to whether there has been a discharge or not can go into certain questions of facts as well, and it cannot be a prima facie determination, which is why it's not for courts at a section 11 stage also to decide the facts of this case, and which is why it has to go to an arbitral tribunal as well. So that is sort of what the judgment says on the questions that you asked.
Thanks, Shruti. So in light of these observations by the Supreme Court, do you have any suggestions for drafting of a settlement agreement which records the performance and extinguishment of obligations under the substantive contract?
Definitely. So I will have 2 points in response to that. So firstly, there's a difference between a simple discharge and a full and a settlement agreement, right? So a simple discharge or a discharge voucher or any agreement which says that this agreement is simply to discharge the previous agreement that has existed between the parties, and there are no new obligations created by this discharge agreement or a consent letter, then that is then that document definitely leaves open some room for parties to then say that no, this dispute can be arbitrated under the arbitration agreement of the original contract, because that new contract does not really create any obligations. But if you were to ensure that no such disputes arise, there are 2 ways to go about it. So one can be you enter into a separate settlement agreement which has separate obligations of its own, which has a dispute resolution clause of its own. So which is why you cannot then go back to the previous contract and say that, okay, there are some outstanding obligations under that contract that remain unfulfilled. And the second thing, the court also says that the parties will have the opportunity to arbitrate such a dispute relating to discharge unless agreed otherwise, which means that if in your discharge voucher or in your consent letter, if you had specifically said that even the arbitration agreement is non-est or there are no obligations even under the arbitration agreement upon the signing of this discharge voucher or the consent letter, then that is a safeguard. So that saves you from the other party then coming and stating that there were some additional claims that maybe were unfulfilled. So I think these would be the 2 practical takeaways.
Thank you, Shruti. I think those were very important points to keep in mind when we are drafting settlement agreements, which is something which is a very common document for parties to sign and amicably settle disputes arising out of any commercial document. Thank you, Shruti.
Thank you so much.
So just to continue the conversation about the judgment with Adimesh. So Adimesh, I understand that this judgment delves deep into the powers of the referral court in a Section 11 petition to see what is the scope of such powers and to understand that what are the questions that a referral court can actually go into at the time of appointment of an arbitrator. So they have gone into the entire history of how the law has evolved on this aspect. They have also gone through the entire plethora of judgments on this aspect, and they have thereafter also dealt with the specific concept of accord and satisfaction and how the referral court should behave in these kind of situations as well. So could you shed a little light about both the generic scope of powers for a referral court under Section 11 to appoint an arbitrator, as well as in accord and satisfaction situations, how does this court deal with appointment of an arbitrator situation?
Yeah, sure, absolutely. As you say, the Supreme Court did discuss a series of judgments in this regard, case laws judgments, but most importantly, the reference was made to an important amendment of the year 2015, in which an amendment to Section 11 specifically stated that a referral court under Section 11 must only look at the existence of an arbitration agreement, or rather, the words were to examine the existence of an arbitration agreement. So taking cue from this amendment as well as other judgments, the Supreme Court has finally concluded that a referral court under Section 11 must confine itself to a limited scrutiny of the prima facie existence of an arbitration agreement. So long as the referral court is able to conclude that yes, there exists or there prima facie exists an arbitration agreement, the referral court should refer the matter to arbitration, or rather to appoint the arbitrators for the matter. Now, specifically for matters which involve disputes on accord and satisfaction, as was the present case, the Supreme Court said that matters involving accord and satisfaction, or rather discharge of contracts by way of accord and satisfaction, the issue is a mixed question of law and fact. In the Supreme Court words, the issue is a mixed question of law and fact. Therefore, this is by default a question which is to be administered and adjudicated by the arbitrator. Therefore, in all matters which involve accord and satisfaction, the referral court must refer the matter to arbitration or appoint the arbitrators in that Section 11.
Thanks, Adimesh. So, we all know that there have been certain judgments of the Supreme Court even post the 2015 amendment where they have given a slightly expansive view of what are the discretionary powers available to a referral court at the time of appointment of the arbitrator. Considering that those are also Supreme Court judgments, is it now the situation that this particular judgment stands supreme and those earlier judgments have been overruled, or will those judgments still be available to parties to cite and maybe take advantage of?
No, so here is where it gets interesting, because the Supreme Court has not specifically overruled the judgments which have maybe given an expansive scope to Section 11. The Supreme Court has only indicated its antithesis to the observations made in those judgments. Therefore, it might be open for a review by a larger bench, and it might be open for parties to take a contrary view to this judgment as well.
Okay, thank you. So, I also understand that in this judgment, the Supreme Court has discussed the concept of time-barred claims.
Yes.
And what should be the scope of the referral court if one of the parties has claimed that the disputes are time-barred? Can you shed some light on this aspect as well?
Yeah, absolutely. So, in addition to discussing generally the scope of Section 11 and also the scope of Section 11 with respect to accord and satisfaction, the Supreme Court also briefly discussed the scope of interference by a referral court when there is an issue of allegation made by the other party to the Section 11 that the underlying claims in the arbitration are time barred. So, in this regard, the Supreme Court referred to an earlier judgment in Arif Azim versus Aspect and indicated that the second issue, which was before the Supreme Court in Arif Azim, that maybe required clarification, and therefore the Supreme Court in this judgment clarified that a referral court under Section 11 must not at all go into a prima facie examination of the arbitration agreement. It must simply examine the existence of an arbitration agreement, and wherever there is an issue of the claims being time barred or ex facie time barred, the Supreme Court or the referral court rather should leave all of these matters to adjudication by the arbitral tribunal. The Supreme Court has also said that these issues should be adjudicated and determined as a preliminary issue. So that speaks a lot for the Supreme Court about how the arbitration matter should go forward.
Thank you. Thanks, Adimesh.